Good morning, everyone.
Good morning.
Morning, Judge.
And I can tell that Counselor White is standing and maybe Andy McSwain. I will tell you all that we've got several minutes of announcements. So if you can, relax. If not, stand at ease. I want to welcome everyone to the 10th Court of Appeals. Please notice that the YouTube Live is illuminated, which means that we are being live streamed at this time on YouTube, and it is being recorded. So I'll get back to that in a moment, but I wanted to draw that to your attention first.
Chief, if I could interrupt you, your video feed is not on, I don't believe.
I believe you are correct. Let me hit this little button right here. Thank you, John. That reminds me that I need to change two quick things here, and I apologize, but y'all will notice that this is not nice and smooth like the Texas Supreme Court does, because we have no technical staff to support us like they do. And in some ways, we prefer it that way. And so let me get one other name change done here. What I am doing for counsel that's on the line, the judges already knew I was going to be doing this. We did this argument or did arguments once before via Zoom, and the primary complaint from the students that watched the video was that they were unable to identify the person that was speaking by the video itself on line. So we did two things today to endeavor to help correct that. One, you will notice I just changed the names of, and I need to change my own name so that they know who the judges are, Rex and John. And so I meant to ask you all to change your names as well. But in the interest of time, next time I will get Nita to do that while we are logged on, and I won't have to do it myself. So you see the timer. It will give you the amount of time remaining for your arguments. It will start with 22 minutes instead of the noticed 20 minutes. I figure we are going to be at least 2 minutes into the delays caused by the Q&A feed. The live feed on YouTube is available for your clients or co-counsel to watch. There is about a 15-second delay between the Zoom meeting and what is happening in the live stream on YouTube. So be aware of that. We obviously ask that you do what we normally would do in the courtroom, turn your cell phones to the off or silent position. We've tried to do that with ours. We can't guarantee that there won't be interruptions, but we have tried to limit that the best we can, given the fact that we are conducting this in the manner that we are. I will point out, if you could jot down this phone number, it's the court's primary phone number. It's 254-757-5200. If any technical issues develop during the course of the meeting, please call that number. That is the court's primary number. All of the deputy clerks know that if you call in, identify yourself as a participant in the oral arguments today, they will come to my office and we will stop the oral arguments until the technical problem is resolved. But otherwise, this is going to be as much as we can make it like it was being conducted in person in the courtroom, with one caveat. Not only are we live streaming this for purposes of open courts provision, we are also live streaming it in connection with blend arguments. Also, Sam Houston was interested in participating as well. We normally travel to the campuses of those two universities once each year, respectively. This would normally be our blend trip, but because of the COVID-19 pandemic, we are restricted to this format. We nevertheless, it's not about merely having the arguments. We have issues in you all's cases that we want to discuss. This was, in other words, it's not just a show. It is because we had questions for y'all of weight on these issues, and we wanted to speak with you all about that. And I don't remember which of you all had participated in arguments after we had started the audio recordings. I think three of the four council here had probably participated when we did audio recordings of the arguments and posted them, linked them to TAMES in our case management system. Now, because we have both the audio and the video, these recordings will stay on the court's web channel, the YouTube channel, and be available for the students in the future, as well as any other person that's interested in how we conducted this proceeding. I ask to the extent possible that you keep your mics muted, and in fact, if you turn your camera off, like mine was turned off when I first started, you will actually drop out of the view that is seen by the court or by the YouTube participants, but you can control your own re-entry into the meeting. So, and it's my preference that you control that and not me, both because it distracts me, as well as I want you to be able to step in if you feel like is needed. For the students that are watching this, because this is an oral argument session, if you are expecting to see counsel rise and object to something, that in 22 years of doing this on the appellate court, I think I've seen that happen twice during the course of oral argument. So that's not what you're going to see, and we will not be announcing a result at the end of the oral argument session. We will get back to the books, as you see behind Counsel McSwain and Justice Neal, and we will be doing the research and writing an opinion, and that's the process that will happen after today. Prior to today's session, we had already received announcements from who was going to do the do the arguments for each of the parties, and so I'm going to dispense with that part of it. But Counsel White and McSwain, are there any reasons to not proceed with the case of BSR versus, and I pronounce it Stabile? Please correct me with the pronunciation if there is another way that I'm supposed to be pronouncing that.
Judge, I believe it's Stabile, and I'm ready to proceed, and I assume Mr. White is.
All right.
Ready to proceed.
Were there any preliminary issues that we needed to discuss with regard to that case?
Not that I know of, Your Honor.
Okay, thank you, counsel. We'll get to it. The other case that's on the morning's docket is Patterson versus State. For the appellant is Lane Thibodeau. For the state is, do you go by Ryan?
Yes, sir.
Ryan Calvert. So I assume y'all are ready. Are there any issues that we need to discuss before we begin?
Nothing from the appellant, Judge.
Nothing from the state, Judge.
All right, then counsel, you'll have 22 minutes to open, 22 minutes for the appellee, and then 5 minutes of rebuttal. Judges, anything that I failed to cover?
We're good.
Mike says I'm good. John says I'm good. And I will begin the at this time, if everybody will turn off their cameras and mics, don't leave the meeting. Just if you know how to do that. If you're not, that's okay too. And Counselor White, you may begin.
Thank you, Your Honor. May it please the court. My name is Greg White, and I represent BSR Surf Resort and the other appellants in this case. This is an appeal of a temporary injunction order. The court may know, but I will say that the injunction was invented by the Star Chamber and the Privy Council in Great Britain under the assumption that the leaders of the law knew better what was right than the people did. And therefore they ordained a result before the truth was revealed in the case. There is an injunction in this case, as the Supreme Court has defined an injunction in Quest Communications. An injunction is an order that restrains motion or enforces inaction. It comes before the determination of liability. It comes with enforcement powers, contempt, separate trial for contempt, jail time is possible, and fines are possible. An injunction controls the disposition of a person's property. I say those things because I think the court needs to know what the case on the merits is about, apart from the problem that appears here with the injunction. This is a tragic death case, and the plaintiffs in the case, who are appellees here, chose to use some relatively inflammatory language to describe what happened. They accused all of the defendants of killing the plaintiff. They say that they are woefully underinsured. They say that their case is worth $15 to $20 million, and that if the defendants are allowed to make a fair market sale of their property, those funds will disappear into a black hole. They claim that by filing suit, they have obtained a lien on the property of the defendants and any proceeds thereof. In reality, the death here, as tragic as it is, and we have to talk about this because they brought a lawsuit, comes from a quite rare circumstance. The CDC says that this organism has caused 34 deaths in a decade. That's how rare it is. The plaintiff, the decedent, was in a different body of water than where the organism was ultimately found. The decedent signed an absolute release of his claims before he entered into the body of water, and the insurance that is available to pay the claim is the exact amount that state law requires. In the face of the inflammatory language used by the plaintiffs, Judge Mayfield, who was sitting for Judge Menard at the time because she was out of town on a personal matter, entered an order, and I think it's important to quote the order. The defendants shall preserve the funds from the sale of assets except as necessary to conduct normal course of business. That is an injunction. There is no dispute that that is an order commanding action and restraining action, which is the classic definition of an injunction. There is no dispute that if it is an injunction, then the order is void. And there is no meaning to the term void if the law is that these flaws do not make the injunction void. There are mandatory provisions that govern the issuance of injunction, and the failure to include those mandatory provisions has universally been held by the courts to make that order void. There are three things that are flaws here, and we've outlined them in our brief, and so I won't spend a lot of time going through each of them, but one of them is there is no bond required of the plaintiffs who are the beneficiaries of the injunction. Now, it may seem that bonds don't really do very much for anybody, but the purpose of the bond shows why it is void why an injunction is void without it. A bond is meant to secure the payment of damages that might be sustained if the injunction was wrongfully issued and is later dissolved. Without a bond, a party who is damaged by an injunction is left to a simple common law claim of malicious prosecution. And this court has been through that circumstance before in American Derringer versus Bond. And in that case, the court said, when you're suing for wrongful injunction and your claim is for malicious prosecution, you have to prove that there is no probable cause for the issuance of the injunction, and there is a presumption that the law abides to the person seeking injunction that they were acting in good faith. If you sue on the bond, that issue disappears. The only issue on a bond is whether the injunction was later dissolved and damages were sustained. By deleting the bond, by not requiring a bond here, the trial court deprived the defendants here of any remedy if the injunction is later dissolved.
Counsel, I won't make opposing counsel's argument for them, but one of the things that they have argued in their brief is that they offered to include a bond or a requirement for a bond in the order, and that you all did not respond to that. And I'm unclear as to whether or not you didn't respond or you said, thanks, but no thanks. That's not what we want. How would you respond to that? I mean,
I think I want to be clear. The offer of a bond is made in the document that was the motion that was being heard by Judge Mayfield. The offer was not, we will supply a bond in any amount that the court requires, and then a response from the defendants, we don't care about bonds. There is a motion where the plaintiffs say we are prepared to post a bond, but Judge Mayfield never brought up the issue of whether a bond should be issued or in what amount. There was no offer for a specific amount or even a general amount. Realizing, of course, Justice Gray, that the property at issue here was the sale of property in the multiple millions of dollars. And so if the injunction was wrong and if it were dissolved, the bond would be, and I won't guess for a trial judge, but I would say it would be fair to call it substantial. It does not surprise me then, nor I think it would surprise the court, to learn that nobody stood up for the plaintiffs and said, we would like to post a substantial bond with 2 good and sufficient securities. So if there is any damage, there will be compensation for the defendants. That's neither the tone nor the substance of anything that happened in front of Judge Mayfield.
is the record going to indicate any discussion of a bond beyond the statement in the motion?
I'm going to say I'm 90% sure that it does not. I won't tell you that nobody said the word bond during the hearing. I will tell you that there was no offer for a specific amount of a bond, no suggestion to Judge Mayfield about what the bond should be, and no suggestion that the order be modified to include a bond.
Okay. I also have reason to believe that opposing counsel is going to be arguing about preservation and
I'm
whether or
prepared
not,
to talk about that.
and so if you could turn, I don't want to not talk about the other 2 criteria, but because this one applies to all 3, can we talk about the preservation issue now?
I'm happy to do that, Judge. The preservation issue goes like this. You, defendants, when you got Judge Mayfield's order, didn't object to it, didn't suggest that something needed to be included, didn't make a complaint at some time. I want to be clear that there was nobody that really got input into Judge Mayfield's order. Judge Mayfield wrote it, which is perfectly fine. We have no complaint with a trial judge that makes his own orders and has his own mind about things. And so there was not an order circulated for parties to approve as to form. Judge Mayfield just entered his order. Now, in saying that there should be preservation of error, in other words, there should be that complaint beforehand, I want to be clear, and perhaps it is not from the briefing that you've read, that that is not what the majority of courts hold. As a matter of fact, 10 courts of appeals say that preservation is not necessary. 2 courts, only Amarillo and Austin, say that preservation should be considered. 1 court has not made a decision, has never faced the issue. This court, the Waco court, is among those who have said that preservation is not necessary. And I will quote from a court case here, the Gray Wireline case. When an injunction is void, it is a nullity, it is of no force and effect, and it confers no rights, whether that has been briefed or not. Courts in Big D Properties and Faskin versus Orley have said it is not waivable. They have used that language. A decision that says that you will have to speak up, you will have to point out an error, that you will have to contest in the trial court a void order, puts a procedural trap over property rights. The courts have always, and I'm going to say that with the lawyer's degree of certainty, and it's not absolutely certain, but it is close to always said orders that issue injunctions without bonds or trial dates or other reasons for their issuance are void. They have never used the term voidable, which is the suggestion that is being made by the plaintiffs here. They have used that term void. They have meant that it is not that it is a nullity, that is of no force and effect, that it has no effect on the parties at all and confers no rights on them. The fact that that term void is used in other contexts to mean that the court lacked jurisdiction does not mean that the word means that in every circumstance. As a matter of fact, the courts have been clear, as has been this court. When we use the term void for describing temporary injunctions, we mean it is a nullity. We mean that it has no force and effect. We mean that it confers no rights. No court has ever equated void with lack of jurisdiction in a temporary injunction context.
Does it matter in this case that the language that is at issue regarding the I'm trying to avoid the label, but I don't know how.
That's okay. Well, I will understand that you're just using it for convenience.
The injunction language in an order that does other things, is that a problem?
I don't see how it could be, Your Honor, because everyone agrees that Judge Mayfield was asked to do this not on the merits of the case. Was the defendant liable to the plaintiff by, in a personal injury matter? That was not Judge Mayfield's decision. Judge Mayfield's decision was a preliminary, provisional, and ancillary matter to the merits. And so he made orders that dealt with discovery, which we do not contest his power to do, nor the propriety of those orders here. But he also did the thing that the law prohibits, which is to control people, to threaten jail, contempt, and trial for disobedience of his orders by issuing an injunction, controlling their actions. And you can't just separate that out. To do that would be to write Rules 683 and 684 out of the Texas Rules of Civil Procedure. A court could do that at any time by issuing broad sweeping injunctive orders, but including a discovery order in it. I will point out that there is one case that is very similar to this, styled Rocklawn LLC versus Paris, a 2015 case that came out of the Beaumont Court of Appeals. In that case, there was a death, and I'm just going to call it a dram shop case, and I know the court will know what I mean, and the owner of the establishment wanted to sell his property after the suit was filed. And the trial court there entered an order strikingly similar to this one, requiring reporting monitoring of financial statements and financial transactions, and requiring a preservation of the assets. And surprisingly, like this court, did not set a bond, did not set a trial date, and gave no specific reasons to support the issuance of the injunction. The Beaumont Court of Appeals spent, I'm going to count, 2.5 pages to say the order is absolutely void, has no force and effect, and was vacated. So the court would not be alone here in deciding that orders, whether they are on the merits, whether they include things that are really discovery related as opposed to having to do with disposition of property. Mixed orders, if I can put it that way, Justice Gray, still can be injunctions and still require compliance with Rule 683 and 684 of the Texas Rules of Civil Procedure.
Because this is an interlocutory appeal, and this one, I don't remember if there is a separate stay of anything from this court. During the pendency of this appeal, and when your issues were framed, is there anything that would prevent the opposing counsel from going back to the trial court, getting these errors or omissions corrected by the trial court, at least addressed by the trial court, and thereby, in effect, moot this appeal?
Well, there is one problem with doing that, Your Honor. When this court ordered the parties to mediation, there is a footnote in it that says, pursuant to section 51.014A12 and B, the trial and all other proceedings are stayed pending resolution of this appeal. Now, we pointed out in a motion to clarify that order that section 51.014A12 deals with an appeal, an interlocutory appeal of a motion to dismiss, which is not what this is. And we suggested to the court that perhaps clarifying that order to say that some things are stayed under 51.014, namely the trial, but other proceedings are not, would be helpful. The reason I say that is because the parties actually went back to Judge Menard on 3 matters. One was a motion for partial summary judgment on the merits. One was a motion to expunge a lis pendens that had been filed. And I'll say that only so that you'll know that despite protestations that they were not trying to stop the sale here, when the sale of the resort became imminent, the plaintiffs filed a lis pendens in the county records claiming that they had a lien, an encumbrance on the property, despite no final judgment establishing that. And so there was a motion to expunge that lis pendens.
So
and a motion
that's a very pleasant way of saying if we had fixed that then, you all could have addressed some of these issues in the interim.
Well, and I don't mean to, I'm trying to answer the question directly in the sense that there was also a motion to vacate the injunction citing these errors that we complain about here. Judge Menard would not hear it in light of the court's footnote that said all proceedings were stayed. Now, that hasn't bothered the plaintiffs one bit. They added 10 parties to the litigation. They have sent discovery. Discovery has been answered, and there are brewing disputes about the sufficiency of the answers. Those things don't seem to be considered stayed by the defendant. But when we attempt to address the merits or this injunction or other action that the plaintiffs have taken, they raised the specter of the stay that this court had entered. And so they asked the court in their response to continue the stay.
Okay, I'm taking it far afield from your the direction you were going. You had discussed the bond issue. You had 2 other points, and you now are down to less than 3 minutes. So I'm going to let you go back to those other 2.
Well, and I'll be very brief with them. The lack of a trial date makes the injunction permanent and indefinite. And that is one of the reasons courts have called that void. And the reasons that the court is required to state to justify its injunction are totally absent here. And one of the quotes that I have from a case called San Antonio Bar Association versus Guardian Abstract is that the reasons are necessary and must be specific enough, and I'm reading this quote, without inferences or conclusions about which persons might differ, and without leaving anything to further hearing. Now, of course, the order here says that you are enjoined to preserve the assets except for in the normal course of business, which just invites further litigation about what normal course of business is. Now, for my last point, I will say that we acknowledge that courts have wide discretion, either under the Uniform Fraudulent Transfer Act or under standard equity injunction to issue injunctions. Fraudulent Transfer Act provisional remedies are no different than standard injunctions when it comes to the discretion of the court. But this is not anything other than an injunction. And I'll say this, that if you looked in the sealed court record at the motion that was filed, the term injunction is used on at least 5 pages. The plaintiff specifically asked for an injunction. They asked for the injunction to prevent further transfer. They cite to section 24.008 of the Business and Commerce Code, which is the Fraudulent Transfer Act. They devote an entire argument to how they meet the standards for an injunction, and they pray for an injunction at the end of it. Arguments here that they weren't asking for an injunction or that what Judge Mayfield did was not an injunction really belie what they asked for and what they received. In Quest, the case that I cited very early on here, the Supreme Court said that it really does not matter what you call the order. If it operates as an injunction, it is an injunction. And there is no serious argument but that an injunction is present here because it restrains. It is not, I will say this, an attachment. An attachment takes property into the registry of the court, into the control of the court, and there's no existing property that was present at the time of this order for the court to take control of. I went over my time a little, I'm sorry.
Questions by the other justices before we turn it over to, thank you, counsel, and let me reset the clock. Counsel McSwain, you may proceed when ready.
Thank you, Your Honor. May it please the court. There actually is a serious argument that this is not an order ordering an injunction. Before we get started on that, though, I would like to thank the court for this setting. I have to tell you that setting this the day after the election saved me from the misery of having to watch all of the election returns last night. So I appreciate that, and I'm forever indebted to you. We have raised in our response and in our various filings before the court, we have raised the fact that this is not an injunction, that it is in fact something very like an attachment that functions and flows from the very relief that TUFTA allows. Since it is not an injunction, since it is very much like an attachment, there is no right of interlocutory appeal under Chapter 51. And the fact of the matter is that despite Mr. White arguing some about the facts of this case and whether or not this was a star chamber type situation, Judge Mayfield sat on the bench as an active judge for 16 years and served as a retired judge for almost 14 years after that. So he has a wealth of experience and he knew exactly what he was doing and exactly what he was hearing from the parties. The fact is that under TUFTA 24.008 of the Civil Practice and Remedies Code, there are several remedies allowed, including an attachment, including an injunction, including any other relief that the circumstances may require. And we'll talk specifically about what Judge Mayfield did at the hearing in a minute, but that is exactly what he sought to do. And
counsel, in connection with the motion that was referenced by opposing counsel, if we go to the motion, is there going to be anything in the motion about an attachment?
There is not going to be anything in the motion that specifies an attachment. But what you will see is reference to at least 7 different types of remedies that are asked of the court, including receivership and including deposits of money into the registry of the court, which in essence is an attachment. The fact of the matter is Rule 592 of the Rules of Procedure specifies that the very language that Judge Mayfield uses in this order, the language ordering to preserve, that very language is used in the attachment rules, Rule 592 and Rule 605 about unrecovered and non-replevied funds. That's the language that's used in the rules. And if you listen to what Judge Mayfield said, and if you don't mind, I'm going to quote just a little bit. This is, and honestly, this is directly contrary to what Mr. White told you about what happened at that hearing. Oh, and I do want to point out one other thing, Justice Gray. In the list of 7 options, which included deposit with the court, receivership, basically anything they could think of that they thought was appropriate under the circumstances, the following line appears. Under all the options, the plaintiff offers to post a reasonable bond and/or to pay for the cost of the receiver. All right. So we proceed and have the hearing, and the defendants are there represented by the counsel, by their counsel. Plaintiffs are there represented by their counsel. This is not a star chamber, right? Judge Mayfield considers whatever is raised by the attorneys. He considers the evidence in the record. And after that, he takes a recess. Here's what happens. And this is on page 36 of that transcript. The court, okay, y'all came in because you wanted to know the answer to this conundrum that y'all have got. This is an extremely interesting matter and a very serious matter for each of you. I've reviewed the statute. It gives the court, in my opinion, wide latitude, fairly wide latitude. There's even a line in there that says any other extraordinary relief that the court is required to order. That's in 24.008, the any other relief that the circumstances may require language. So I'm going to ask you to redraft your proposed order for me and add some language there. He goes on to say about the plaintiffs being concerned that assets could disappear or be further liquidated. And he says, I also understand the argument that there are responsibilities and obligations. Obviously, placing the funds in the registry of the court creates an undue burden on everybody, in my opinion. We'd be down here having hearings constantly. And he goes on to say, talks about the appointment of a receiver. And then he gets to the crux of what he does in item number 2, which is the only item in this order that the defendants complain of. The other items are discovery type items. He says, the plaintiff has requested, and I think there's enough evidence to support this request, that the court order that the money stays at this point, or the proceeds of the sale stays with the LLCs or with Mr. Parsons. But the LLCs and Mr. Parsons are to file monthly under seal bank statements indicating the transfer of any assets and that sort of thing, so that the plaintiff is in the position of seeing if there's some type of fraudulent transfer in the future that would justify a receiver or further injunctive relief or the removal. In addition to that, and then he goes
Why
on
is that limitation on what they can do with their property not an injunction?
Your Honor, it is not an injunction. Frankly, the order to preserve, as I said, is consistent with the actual language of the rules that talk about attachment. More than that, the relief that he granted was less than a deposit in the registry of the court. It is less than the receivership that was asked for. And the injunction cases that the defendants have cited here that talk about, the ones that they've cited where they say clearly this is an injunctive order, the relief in those orders, number one, is widely broader than the preservation relief requested here. And more than that, none of the parties in those cases contested the label that was put on those orders by the trial judge that they were actually injunctive orders. And so in this case, the order to preserve allows the defendants to do a good many things with the funds, including investment. All that means, all the order to preserve means is it can't go away. And that serves the underlying basis of TUFTA, that the defendant not be allowed to secrete funds away from the ultimate liability that they're going to be faced with in this case. And so we believe that this is not an injunctive order. We believe that the cases that are cited are inapposite because there's not a single one of them where this
John,
issue
you
is.
just have to jump in there and ask your question. He's not going to stop.
Sorry, I'm sorry. I'm sorry.
I'm just having a hard time distinguishing between an injunction and an order to preserve. I know we're calling them different things, but in my mind, I'm having a hard time distinguishing between the two. Tell me the characteristics of one versus the characteristics of another so that I can make that distinction.
The attachment and the cases that we cite in our brief talk about basically an attachment being a situation where personal property is put into custodial allegiance. In other words, under the review or the purview of the court. And in this case, and so clearly the cases in the Zhao case and the Lessaker case that we cited, where the funds are actually required to be deposited into the registry of the court, either as an attachment or under the court's inherent authority, are clearly non-appealable and clearly not injunctions. The requirement that the funds be preserved is not a requirement that, like you see in these other cases that are cited by Mr. White, that you can't transfer, distribute, secrete. You know, those are the kinds of things that you would see in family law cases that prevent you from doing anything. And in this case, the order to preserve is frankly nothing more than keep it safe. That's what and I understand that there's a line drawn exercise between attachment and temporary injunction. But what I also understand is this is the very language that's used in the attachment rules in the rules of procedure. The order is to preserve and is to put into custodial allegiance. And frankly, along with the discovery orders that are issued in this order, along with item 2 that are not appealed, that's exactly what this order does. Now, I'd like to turn, if I might, and I'm happy to answer any other questions on that topic that I either answered well or I didn't. I'd like to turn, if I might, to if the court believes that this is actually an interlocutory appeal that ought to proceed, I think that this error has been waived. One of the things that Mr. White said in his opening that is absolutely incorrect is that Judge Mayfield simply formulated an order and signed it and sent it out to the lawyers, and they had no chance to deal with it or to object. The fact of the matter is there is a 9-page section in that transcript where Judge Mayfield told the parties, 2 defense lawyers, here's what I'm going to do. The 2 defense lawyers chimed in and asked questions, asked Judge Mayfield to clarify. Not once in their response to the motion that was filed by the plaintiffs, in their appearance before the trial judge, in their response to Judge Mayfield after he told them what he was going to do. Not once did any one of them, either one of the 2 defense lawyers say, Judge, you know, this is an injunction and you're going to have to set it for trial and you're going to have to require a bond to be posted and you're going to have to require specific statements in the order about the harm to be suffered and what's being remedied. Not once. 9-page discussion with Judge Mayfield. If you look at it, you'll see they were asking all kinds of questions about what the order meant. Not only that, at the end of that recitation, Judge Mayfield gave them his cell phone number and said, if you have any problems with this order, let's have a telephone conference. What was the next thing they did? They filed an appeal. They didn't ever contact Judge Mayfield to give him the opportunity to cure the very complaints that they're making here. Now, I understand that there is a split in the courts of appeals on whether or not these requirements in Rule 683 and 684 are void, create void orders. I will tell you, and we've cited a couple of the cases, that even in the majority of the courts, and Waco's one of them, those orders are not treated as void. For instance, we cite to a couple of cases where courts of appeals have said you can't collaterally attack a void temporary injunction order once appeal timelines have run.
Isn't the remedy in that situation that you go back to the trial court and you ask for a modification of the temporary injunction, and then that becomes a separate order that can be appealed?
Judge, I don't know that. I mean, honestly, that may well be right. That happened in one of the cases that we looked at. And in that case, the Court of Appeals, and I don't remember the case as I said here, but in that case, the Court of Appeals said, well, the foundation order that you're working off of is one that, so they appealed the refusal to dissolve. And the Court of Appeals in that case, and it's cited in our brief, said, it doesn't matter. The foundation order that you're working on was one where the appeal deadlines have already run, you lose, right? But in truth, if it's a void order and a nullity, then it doesn't mean anything. If you look at, and so the point of our argument about, preservation is this. They were represented by lawyers. This is not a star chamber. They had ample opportunity to stand up and open their mouths at any point during the proceedings and say, Judge, if you're going to do this, you got to do these three things. More than that, the Supreme Court, since the year 2000, in the case called Dubai that we cite in our brief, has embarked on a clarification of what it means to have preservation of error rules. And this court has dealt with that a little bit. But what has devolved is the Supreme Court has in a number of cases, and we've cited them in our brief, Supreme Court has staked out a position between procedural rules or prudential rules and jurisdictional rules. And what the Supreme Court has said is, unless it is a jurisdictional rule, preservation of error is required, unless in the limited exception of fundamental error, which Judge Gray, you have categorized in one of your writings as a discredited doctrine, primarily because it arises so infrequently. And so if you look at it, the last of the cases that deal with temporary injunctions from the Supreme Court. Sorry, I've got to get these out of my stack.
That's okay. My whole workstation is set up differently now because I'm trying to use it as a bench and it doesn't work well.
Right. So Quest, right? So Quest versus AT&T is the last Texas Supreme Court case that deals with temporary injunctions and the types of technical violations that we're talking about here. Quest says, was issued the same year as Dubai, right? And Quest says, specifically, these procedural requirements are mandatory, and an order granting a temporary injunction that does not meet them is subject to being declared void and dissolved. And it goes on to say, here, these procedural requirements may render the trial court's order void, may render it void.
Isn't that what we're here, though, counsel?
That's what we're here for. The interesting thing is, if the Texas Supreme Court had meant that the order was void as it sat there, it could have said that. It could have said void ab initio, right? Void ab initio.
But does it matter if we characterize it as void ab initio or voidable? We're here on a direct appeal of an accelerated review, and there's a compounding problem if you require preservation in the nature of a motion for reconsideration, because you've got 20 days to file your notice of appeal, which led to my concern about whether or not y'all could have fixed this in the meantime. Well,
and I think Mr. White addressed that, but Judge, the fact is it does make a difference if it's void or voidable, right? If it's voidable, if it's subject to being declared void, then preservation is required. For instance, if you look at Rule of Appellate Procedure 33.1, that sets out the requirement that preservation is required for everything in front of the Court of Appeals. 33.1 doesn't have a carve out for Rule 683 and 684. There's no carve out there. If you look at a simple word search of the rules of procedures, right, will show you that there are over 1,400 times that the word shall is used, and over 600 times that the word must is used. If you're going to hold in every circumstance that those directory terms are effectively jurisdictional under Supreme Court jurisdiction, what a mess we would be in, because you would never have any finality in any type of order, and you would constantly be fighting about, is it final or is it not? Is it jurisdictional or is it not? So the cases that we've cited in several different contexts all show that the Supreme Court since the year 2000 has been on a course of saying procedural, prudential versus jurisdictional. If it's procedural, you have to preserve error. If it's jurisdictional, you don't. The only circumstance that works otherwise is fundamental error. And this is not fundamental error. It never has been held to be fundamental error. Judge Gray, I would say that if you look at the Menchaca case that we've cited in our brief, 2018 Supreme Court case, it shows you how limited fundamental error is, with the purpose being that you want to promote efficiency in the judiciary, you want to allow the trial judge to correct their errors, and you want to have closure for these orders instead of void orders going forward. Frankly, the concurrence out of the Chief Justice of the Houston 14th Court of Appeals, the Chief Justice Frost, that's cited in our, I think it's heavy lift truck is the name of the case, or hydro lift truck. Hoist, sorry, I was corrected, hoist lift truck. That concurrence came in 2016 and is very well written. It's worth a read because it explains this whole dichotomy between procedural and jurisdictional errors that the Supreme Court has laid the groundwork for. The fact of the matter is that temporary injunction rules, particularly with parties represented by counsel, are not sacrosanct and not any different. One of the places we can go to see that is Rule 682. You know, Rule 682 requires a verified petition before a temporary injunction or a temporary restraining order can be issued. Guess what? That can be waived. And it uses the same shall language that Rule 683 and 684 have. Rule 166A about summary judgments has a bunch of shall language in it, along with may language, right? Directory and permissive. And yet every single one of these shall instances in Rule 166A can be waived. So the cases we've cited show that the Supreme Court is headed in the direction of determining error preservation issues, even in serious instances like termination of parental rights, on the basis of, is it a procedural or a prudential consideration or a jurisdictional consideration? If it's not jurisdictional, you have to preserve error. And you think about, Judge Gray, you think about, and I say your name because you cited to a case called Vega versus State, which was a stare decisis case. I believe that the majority of these cases that follow the subject to being declared void language and treat them as void without preservation, I believe those are wrongly decided. The Supreme Court has not acted on those. And if you look at it, what that does, you've got Mr. White made arguments that, the defendants deserve to be protected. Well, there wouldn't be a temporary injunction unless there was an injured party that deserved to be protected too, particularly in front of a seasoned trial judge like Alan Mayfield. And so the fact of the matter is that if you allow the majority view to prevail, then what you've done is you've allowed a potential wrongdoer in the face of harm to an injured party to lie behind the log, sit on their hands, create a situation where there is a void order with which they do not need to comply, and then claim on appeal, I was wronged because the order is missing these technical defects. I appreciate your time. Happy to answer any questions. I would suggest, I was going to quote it to you, but I would ask that the court read the concurrence from Judge Frost in Hydro Lift Truck, read the statements in Vega versus State regarding cases that are wrongfully decided, and the right and frankly the duty of the court to rethink positions that may be in fact incorrect. Thank you.
Thank you, counsel. Counsel, you have 5 minutes of rebuttal. You may proceed when ready.
Thank you, Your Honor. I would also recommend reading Hoist Lift Truck, mainly because the majority opinion there declares the temporary injunction void for lack of a bond and other requirements. It was written by Justice Busby, who now sits on the Supreme Court. The fact that one of his colleagues disagreed with him on a matter of predicting what the law would be in the future, I think it's equally important to know that the majority of the 14th Court and 10 other courts of appeals are following a century's worth of Texas jurisprudence that holds these void, including the Quest Communication versus AT&T case, where the Supreme Court ordered the temporary injunction void and dissolved because it had no bond. Bond provisions are mandatory. I also cited the court to the Rocklawn case out of the Beaumont court. That was the dram shop case. And a footnote there, the court notes that if an injunction is void for failure to comply, the error is not waived just because the parties agree to the form of the order, and cites a number of cases that say that. In that case, the court was also asked to, judges, don't declare the order void, modify it. You put the bond in it. You put the trial date in it. You correct all the errors. And the court refused to do that in any way, shape, or form. So I hope that the court appreciates, and I respect any person who wants to argue that the Supreme Court is heading in a particular direction because of the theory of the law or the jurisprudence that goes behind it. But the court did not take the Hoist case up on a petition for review, nor has it since the Hoist case in 2016, which makes that 4 years, decided that it's going to address this preservation of error doctrine, reverse 10 courts of appeals who have held that preservation is not required, and take a new tactic. There's no reason for this court to do that, to make that prediction that the Supreme Court is going to go that direction in the face of so much authority that goes the other ways, and in face of so much practicality that says that that just can't be done. As Justice Gray noted, if I get an order on day 1, and day 20, I have to file a notice of appeal, and I have to be prepared to brief it immediately. Where's my time to go back and file a motion for new trial or motion for reconsideration or notice of errors here? Get that heard, decided, heard, argued, and decided. It would certainly be impossible in our COVID calendar. Hopefully we will be back on a calendar where judges, don't have to deal with these inconveniences of getting parties together. I wanted to talk about just a couple of other things. The attachment argument, of course, is being made only so that you will dismiss the appeal as having no jurisdiction. But there's nothing about this that makes it an attachment. An attachment is the court taking custody of existing property. That's the theory behind attachment, not the court telling people what to do with their own property that they own. And attachments require bonds too. So if the court said, well, this is an attachment, and you filed an appeal, I think the court was well within its power to say, and we're going to treat it as a mandamus because bonds are equally mandatory in attachments. And I will tell you that of the 7 options they asked for, one of them was an injunction, and they asked for it repeatedly. I'll yield the remainder of my time. I would have gone off into something else, but I think it's better for me to just say, If you have more questions, I have 40 seconds or so to answer them. And if not, you would probably appreciate me giving some back.
Rex, you're muted, but do you have any questions?
Got one. Where did you go just now with the treated as a mandamus and the bond procedure? I don't want you to have to take a whole new tack, but I'm curious about that. Flesh that out a little bit.
Well, the court has, and I didn't cite these, and I'd be happy to provide a letter brief if that's something the court desires. But the court has said interlocutory appeals that are filed and the court has no jurisdiction, the court may treat them as a request for a mandamus. And if you're convinced that this is an attachment and not an injunction, then it's pretty clear that the same violations that we argue existed as to this order, the lack of the bond, the lack of a trial date, those apply, well, the trial date doesn't apply, but the bond does apply equally to attachments. And we're in the same disadvantageous and violative condition. And the rule is absolutely violated by no bond. And there's no question that these ancillary orders that are, compelling things to happen or taking property from people require bonds. So the court should do that.
What would treating it as a mandamus under these particular facts and this record, what would that gain one party or the other, frankly?
Well, of course, I only speak for what it gains for my side. And so I really don't want to be totally objective and say what it's good for the other side. But the court would, if it treated it that way, do the same thing that we've asked here, which is to vacate the order. It violates the rules. Send it back to the trial court. And as Justice Gray suggested, perhaps then with the trial court having power to deal with the order, it might make some kind of remedy that actually complies with the rules and does whatever the court thinks is appropriate upon consideration of the evidence and the history of the case and whatever the trial court wants to do.
Thank you.
Any other questions? Counsel, this case is submitted and you all are excused. I'm assuming that you all received the link to the 12 o'clock Q&A session that's going to be held with the students, hosted by Blinn. Maybe you didn't. It's not mandatory by any stretch of the imagination. Normally, when we hold these on campus, we invite counsel to a luncheon, either after their arguments or if they're in the afternoon session, it's before their arguments. But since we weren't able to do that, we sometimes take questions from the audience. I assure you that no merits-based questions will be discussed at that time. And so it's a brief opportunity, but if you didn't get the link and you do want to participate, call back to the court, ask Nita, and get to the clerk, and she will provide you a link to that Q&A session. But again, it will be non-merits based. One other small feature or comment. This is only the second time we've done this. We're trying different things. We're trying the robe. We're trying the change of the name on the screen. You've seen my little markers over here with the timer to identify who is speaking. If you see something else like that, procedural in nature, that you think will make us be able to conduct these hearings in this format better, please feel free to contact us with that information.
I'll give you one short comment. The shot clock in the upper left corner is spot on great.
Okay. I've
seen it other ways, and this is perfect for me.
Okay.
I agree.
My endorsement there.
All right. Well, with that, we appreciate it, counsel. This case is submitted and y'all are excused.
Thank you, Your
Thank
Honor.
you.
Thank you.
Judges, do we need to take a recess before the next case?
I'm okay.
Yeah.
I think that is a 5 minute. Are you
5
okay, Rex, or do we
Great.
need to take 5?
I'm gonna hop up and hop back. I'll be right back.
All right, we're going to take a 5 minute recess before the next case. Hello, gentlemen, and let's see, I need to turn. Any questions while we're waiting for Rex's return?
No, sir.
Okay.
No, sir. Judge, Justice, Chief Justice Gray, I will tell you that I have no way of controlling the train that may be running down the track in close proximity to where I'm sitting right now.
If
Mr.
it comes
Calvert
to
knows
that,
the
I'll
issue.
pause. I'll pause the timer if it's your time to talk. So
I will stipulate that from Lane's position that the train is an issue. So.
I know, I forget which courthouse it was, but there was a trial courthouse that had the same issue. We can actually hear it from here, but it doesn't completely shut us down. But I was trying to listen to a audio record of a hearing one day, and I mean, it was like whatever happened during that 30 seconds that the train was going by didn't happen as far as the record was concerned. So
Counsel, I'd like to participate, but the host has blocked me.
you should be able to do your own, start your own video.
Actually, it sent me a note that said, I can't do it. You have to do it.
All right, try it again.
There we go.
Okay. All right, counsel. Let me set your timer, Mr. Thibodeau, and we will. I know you don't want to start with 5 minutes. That looks about right. Counsel, you may proceed when ready.
May it please the court. My name is Lane Thibodeau. I'm a lawyer in Bryan, Texas. I represent Sam Patterson in connection with this Fourth Amendment search and seizure issue that we've got before the court. This case, as the court is aware, arises out of a search of a fraternity house here in College Station, the Sigma Nu house, and 25 rooms, apartments, living spaces inside the Sigma Nu house that was occasioned or triggered by the overdose and later death of a young man by the name of Anton Grubnev. Now, the issues that are framed in the briefing, both by the state and by me, really begin with what is the space that is subject to Fourth Amendment and Texas constitutional protections. I think that that issue has been framed well for the court, as well as the warrantless entries that were made into the various rooms. The one that I'm concerned about is living space 216 on the second floor of the Sigma Nu house. If it was Sam Patterson's room, living space, apartment, however you want to label it, on the second floor of the Sigma Nu house, that was his constitutionally protected living space, then from there, the rest of the arguments necessarily flow. So what we can say based on the record from the suppression hearing, and of course there were several parties that were participating in the suppression hearing, is that this, the search of Sam Patterson's living space on the second floor was triggered by a series of telephone calls that came in to various 911 dispatchers in the College Station area. Specifically, there were 2 that came in from a woman by the name of Emily Peel, and a third call that came from inside the Sigma Nu house. the information that was communicated at the time to the to College Station Police Department officers and the specific individuals that were involved here that are significant and testified at the suppression hearing. The first arrived was Sergeant Taylor. The other sergeant that testified and arrived shortly thereafter was Sergeant Patrick McCarthy. There were several other officers who testified at the suppression hearing that took various roles in connection with the search of the various 25 rooms inside the Sigma Nu house, including Officer Pierce and Officer Reismeyer as well. These calls that came in about 4:30 on August the 20th of 2016 advised the College Station Police Department that significantly Anton had suffered an overdose. That came from Emily Peel. There was also information communicated by Ms. Peel that it was heroin that he had overdosed on, and that there were other drugs inside the house, or at least there was drugs there. Now, there was a fourth call that came in at some point from the College Station Police Department, but significantly, at least for purposes of our discussion here today, at least as to the warrantless exceptions, the exceptions to the warrant requirement, from the context of that call, that came in after Anton was in the ambulance and actually being transported to College Station Medical Center, which is not terribly far from the Sigma Nu house. So at the time that Sergeant Taylor arrived at the Sigma Nu house, he knew that there was a reported overdose. An ambulance had arrived at the Sigma Nu house shortly, seconds before he got there, but long enough for paramedics and first responders to actually be administering first aid or CPR to Anton. Now, let me step back and say to you all that his death was a tragedy. It was awful. It happened a week before the beginning of the fall 2016 semester. But as it pertains to the Sigma Nu house itself, Sam Patterson testified as part of the establishment of the standing in the case, and that the things that he testified to are consistent, not consistent, but I believe are controlling under State versus Rodriguez, the case that we have discussed in that I have written on in my briefing, both in terms of the appellant's brief and the reply brief. Rodriguez versus State is, I think, determinative or at least compelling as in terms of what the privacy interest here or the trespass, regardless of theory, trespass or privacy, was in fact protected. The dorm room at Howard Payne University that the Court of Criminal Appeals determined was a home away from home virtually goes on in all fours, almost all fours, in terms of the Sam Patterson's room 216, his living space there at the fraternity house. Now, Patterson testified that he had the right to exclude others. He considered that living space his home. The state certainly established, because there was really no issue about historical facts, that there were common bathrooms, there was a common kitchen, there was a common mail drop, and in fact that there was a keypad outside the front door that fraternity members had access to. But Sam Patterson leased his room, leased his living space. He testified that the defendant's exhibit number 1 to the suppression hearing was his written lease. He had paid rent. He gave the number. He considered it his private space. In fact, Mr. Calvert asked him,
to the extent that it matters, however, the lease, I think Patterson's lease in particular was not signed, but it did not assign a particular space to Patterson. Is that correct?
That is correct. The lease did not, nor was it signed, but Sam Patterson, because he testified, he said, this is the lease. This is the lease that I signed and that I tendered money to pay for. This was my place.
lease was the lease for the Sigma Nu building itself. Not a, I mean, didn't the lease say he's leasing space in this particular building?
He did, yes, sir. It says specifically he's leasing from the Sigma Nu fraternity the living space that he was paying $650 a month for. And he did testify that although what we tendered as far as the exhibit was unsigned, that was the lease. That's what he was paying for, and that was the lease that he had signed within the month that he was that this all occurred. Let me also say that the lack of a number on it, if you compare the lease that was signed at Howard Payne University in the Rodriguez case, the Court of Criminal Appeals found, in fact, it gave privacy interest. In fact, the lease that we had that Sam Patterson signed, that Sam signed, I think provided more protection in terms of the written lease than what was at issue in Rodriguez. In Rodriguez, the university retained the ability to go into the home for security checks, to do maintenance, to do things of that nature, and did not, importantly, assign a room number. There's nothing in the Rodriguez lease that the lease in Rodriguez for the dorm room that assigned a particular dorm room to Miss Rodriguez, who was also sharing the room. So in that regard, although there was not a specific room lease, I think if you take a fair reading and compare the leases and the indicia of privacy that are provided by the leases in Rodriguez and Howard Payne University to what Sam Patterson was paying for inside the Sigma Nu house, you'll see that there was no right for Sigma Nu administrators, the national fraternity, or officers of the Sigma Nu chapter to get access to his room, unlike the lease that was found to provide, or at least was part of the evidence that the Court of Criminal Appeals decided gave Ms. Rodriguez these privacy rights.
You pointed out one fact that I had missed in Rodriguez, if I understood your recitation correctly. Did you say that in Rodriguez that she had to share the room with another person?
Yes, sir. I think that she had a roommate. I believe she had a roommate.
Was there any indication in the case about how that roommate was selected or chosen?
No, sir, there was not. And that's part of my, in terms of the larger issues of privacy in this case, there was a roommate in Rodriguez that was not here. I think under our existing, whether it's Baylor, I've certainly made this point in my reply brief, whether it's Baylor, whether it's Texas A&M, there is this many times in honor dormitories or freshman dormitories, individuals are grouped by majors. Obviously, this was a fraternity house with individuals that were that called each other brothers, that had a relationship with one another, no doubt about that. But that is not terribly unlike most of the ways that on-campus dormitories are done these days. I would also argue that, again, by analogy, if we take this out of the fraternity house and put it into, for example, to a hotel, or a hotel where a class reunion is being held, or where a service organization like the Shriners are having a convention that leases several floors, there's relationships there, there's individual leased rooms there, but that would not, in my mind, change the outcome that the individual room leased, for which there is payment, for which there's privacy interest, locks on the door as there was on 216 Sam's room. He also didn't receive his mail in the common mail drop. I think that's significant because although there was a common mail drop, Sam testified specifically that he did not receive his mail there. He got his mail someplace else. So
your time is expiring, and I need you to move on to the different bases of the sweeps.
Say that again, Judge. I'm sorry.
the different bases for conducting the sweeps that the state has argued. And
Yes, sir.
which of them we can rely on or not.
Well, you know, I think there's three specific ones here, and I'm going to concentrate on two. One's the community caretaking emergency doctrine. Now, the cases that we've cited, and I think that the briefing is specific, is Laney versus State, the Supreme Court in case of Mincy versus Arizona. That community caretaking emergency doctrine, I think is the most likely argument here for the state to say that there was a legitimate warrantless entry into Sam Patterson's room.
Give me the three that you're going to talk about so that I can keep them straight.
Community caretaking for emergency aid, exigent circumstances based on imminent destruction of evidence, and 3, implied consent. I'm going to spend most of my remaining time speaking about the community caretaking emergency aid and the exigent circumstances based on imminent destruction of evidence.
Okay.
The emergency caretaking case doctrine, which would allow the law enforcement acting divorced from their law enforcement capacity to enter into a private space for a specific objectively based emergency. It is my position that it does not apply here because the specific emergency, like in Mincy versus Arizona, was as to Grivnev. The specific telephone calls that came into 911 call, the 911 calls were all tied to Grivnev. They weren't tied to anybody else. And when Grivnev was transported by ambulance to College Station Medical Center, that emergency expired. There was nothing other than what I would say an inchoate, a generalized fear that, well, there may be other people because there was reports of drugs and because there were intoxicated individuals that allowed the police to go into the other rooms. It is my position that there was no specific, and it has to be specific. If you look at Laney versus State, the language that's used there is specific, and it cannot be. It's an objective standard, and it must be as a result of a specific danger to life or limb. And I have to mention the Bray case in connection with this, because drug overdose cases have been litigated before. Bray versus State Court of Criminal Appeals specifically says that overdose is not a talisman that authorizes warrantless searches. Some reported overdoses will involve emergencies that justify a warrantless search, but this was specifically tied to Grivnev. Further, and I make this point, we do not know, and the evidence does not support which of the 3 warrantless entries, or at least the first 2 warrantless entries, and we know that there were 2 warrantless entries before Investigator Garrett came in to document the paraphernalia and drugs found in various rooms in plain view. And we don't know which of those 2 searches the drugs, at least as to Sam Patterson, were seen in plain view. In fact, Officer Pierce specifically testified that they went in a second time, and that he performed the second sweep sometime after the first sweep, and it was then that he observed drug paraphernalia in plain view. Now, if the first sweep was somehow justified under the emergency doctrine, this second entry, warrantless entry, was not, at least on the community caretaking. And there's plenty of evidence that, in my mind, would say that particularly the second warrantless entry was not divorced from the law enforcement, the role of law enforcement in investigating for drugs. And in fact, the record is replete with evidence. Officer Chris Dawson, D-O-W-S-O-N, specifically made entry to take photographs was photographing when she was told, no, you're not supposed to be photographing, back out. Officer Torres testified on the defendant's case that he was told that this was part of the investigation. the second entry. He was instructed by Sergeant McCarthy to go back in, that it was part of an investigation, drug investigation at that point. That would lead me logically into the imminent destruction of evidence argument. And the cases related to that are well known. First, there has to be probable cause, and that has to be specific. In my argument here, the specific probable cause as to room 216, not the general structure. Sam Patterson's room, room 216. Sam Patterson was with with College Station Police Department from the moment Sergeant Taylor arrived at the scene to the time that he was arrested. He posed no imminent threat of destruction. He was constantly in the presence of College Station PD officers.
What about the testimony where he was trying to leave the group and go somewhere?
Judge, there was testimony from Officer Reismeyer that he tried to go upstairs, but he twice, after being secured in the pool room downstairs, but he complied with commands both times and went back into the pool room where they had everybody corralled. In my mind, that is evidence of a lack of imminent destruction. And the word imminent means something here. Words mean things, and it's not just a general possibility. It has to be imminent destruction. And the cases that speak to the imminent destruction of evidence, the Turbiate case and the Davalos case that have been cited in the briefing, make that point, that there wasn't this rustling behind the doors. There wasn't these things that would indicate or have the indicia that there was a danger that there was going to be evidence destroyed. Certainly there was a common bathroom. It wasn't going down the toilet, but more importantly, Sam Patterson, although he tried to leave the common area twice, was never in a position to do anything with respect to that. More importantly, there's nothing to indicate that there was an imminent destruction, that there was probable cause, that there was drugs in that room to start with. If in fact that's his privacy, that's the space to which his privacy interests belong.
Let me ask you about the search warrant. There is a line in the probable cause affidavit that says something to the effect that drugs were seen in plain sight in these spaces, and it infers the first sweep.
Judge, if you let me answer that directly. Special Investigator Riley Garrett, who was dispatched out to the scene at 7 a.m. about 2.5 hours after they made their initial entry, did testify. It's in the record that he did not know there were two sweeps. That testimony is in the record, that he did not know that there had been, my words, two warrantless entries into these living spaces.
And that is basically documented in not only in the testimony, I guess, but the probable cause affidavit doesn't break them out separately. Therefore, Judge Spillane would not have known about it if the warrant was improperly issued because of information not known to Judge Spillane. But could he have, in other words, is this a good faith exception issue that Judge Spillane didn't know that there were two because Garrett didn't know there were two, therefore it's not a problem, they went in under a warrant?
That's a possibility, Judge. I will acknowledge that it has to be judged by the four corners of the affidavit, but that has to be judged by either the emergency doctrine, even if they're on a good faith basis, or in my mind, the lack of probable cause and imminent destruction of the evidence. I've not had a chance to talk about what I believe is facial invalidity. I might be able to get to that in my rebuttal. Thank you.
Go ahead and spend a minute with it right now.
Judge, I mean, that issue has been briefed extensively. From the jump, And again, this warrant was secured 7 hours, or signed, I should say, 7 hours after the initial call to College Station 911. It was signed, I think, at 11 or 11:30 in the morning. The response had been at 4:30 a.m. But what is important about that is that the College Station Police Department treated this structure as globally from the jump. And it didn't change when Riley Garrett went in front of Judge Spillane. He knew, because it's documented in the warrant within the four corners, that these were individually leased rooms. He says it in the affidavit. He corresponds rooms, which is another thing. He corresponds the specific living spaces, 216 in the affidavit, to Sam Patterson along with the other individuals. He knew that these, because he talked to Aaron Springs, the manager, and had gotten all of that information, but he still presented a warrant that authorized the search of the fraternity house structure itself rather than the individual rooms. So that would not qualify as a good faith, because the cases that have interpreted that generally have said, well, there was a lack of information available to the magistrate to know that this was a separate private space, and that's not the case here.
Okay. Questions by the judges?
There's a line of a couple of cases that the state refers to, federal cases, on the standing issue, on the expectation of privacy issue, the Wera, W-E-R-R-A case, and the McClellan case.
Yes, sir.
Distinguish those for me.
Judge, in my brief, I've gone to great pains to distinguish those federal cases. The McClellan case was out of Milwaukee, Wisconsin, and it involved two rooms inside of two apartments inside a larger structure, and that was an ongoing federal drug conspiracy, and the affiant did not know that there was, in fact, these separate apartments to that, because it was a conspiracy and was subject to a long-term conspiracy investigation. There was information that the whole structure was involved. That's not the case here. Wera is completely inapplicable. I think Wera involved a sober living facility, if memory serves me. And in fact, it found a privacy interest existed because the individual that was arrested on gun charges was searched in a common foyer. The last case, which I think was the McClellan case, if I'm not mistaken, I have my brief in front of me here, involved a child pornography investigation where there was, I think, 3 individuals living together. There was a common IP address. So the focus of that was, in fact, the child pornography with the common IP address involving all of them. It was also subject to a long-term surveillance, and that's why they knew that there was a common mail where everybody, and again, that's different from our case because they didn't know that. And in fact, Sam testified, I got my mail elsewhere, while in that case, it was out of Massachusetts, everyone used the same mailbox. But most importantly, I believe for that case was the common IP address from which the police knew that child pornography was being distributed or at least consumed.
You good with that for now, Justice Neal?
I am.
Justice Davis? All right. At this time, I'll reset the clock. Ryan, you do not get to start with 24 minutes.
Thank you, sir.
But we'll negotiate on that later if you need more time.
Yes, sir. Thank you. May it please the court and my good friend, Mr. Thibodeau. Good morning. My name is Ryan Calvert. I'm representing the state of Texas in this case. I wanted to begin by addressing something that Mr. Thibodeau spoke to just a moment ago. And Chief Justice Gray, I want to go back to a point that you made. I believe you're correct that good faith ultimately would apply, but I wanted to correct one thing that Mr. Thibodeau talked about. He was discussing Riley Garrett and the probable cause affidavit and the knowledge, subjective knowledge of Investigator Garrett that these were, as Mr. Thibodeau put it in his brief and his argument, separate apartments, or that this was a multi-dwelling structure. The record does not reflect that. In fact, Riley Garrett specifically testified, and I believe it's on page 240 of volume 2 of the record, the suppression hearing. Investigator Garrett was being asked about this notion that this building was akin to an apartment complex, and in response to a question about how one room was nowhere near, I believe it was room 215 if memory serves, was nowhere near where Anton Gridnev's body was found, Mr. Garrett, Investigator Garrett responded, well, they're located in the same residence. And so it's clear from Investigator Garrett's testimony in the record that the trial court heard that he considered, and that all of these officers, if you look at their testimony collectively, considered this to be one resident.
Okay. I need to stop you there because we're melding a couple of issues together. If we're looking at good faith potential, that gets to what's in the probable cause affidavit, and the probable cause affidavit certainly reads, as Counsel Thibodeau referred to, that the affiant did break out individual rooms with individual things found in individual rooms and discussed it that way. So do we have to look at the testimony differently in light? In other words, we can't do that for the probable cause, but and I guess I'm a little bit confused about how Officer Garrett or Detective Garrett wouldn't know that it was separate rooms, given what was in his probable cause affidavit that was far in advance of his testimony at the suppression hearing.
Sure, and to address that question directly, I believe what the testimony at the suppression hearing was about how Investigator Garrett equated particular rooms with particular people is the College Station Police Department and Investigator Garrett specifically was receiving assistance from a senior member of the fraternity and a resident of the house. And that individual gave Investigator Garrett, and he testified about this, gave Investigator Garrett a list of who lived in what room. That's the same individual, incidentally, who during the sweeps was escorting officers through the house, helping them knock on doors, and even had a master key and helped them open doors to look for people as they were sweeping the house, looking for to make sure everybody was safe and did not need assistance.
I got to ask this though: that help was rendered in that fashion was to keep from kicking the doors down like they did one, right?
They did kick, I believe it was actually 2 doors in the house to access them when they didn't get a response. But yes, he was. But getting back to a related issue on this topic that Mr. Thibodeau, both in his brief and in his argument, put great importance on, he talks about the 3 warrantless searches, or at least the 2 sweeps prior to Investigator Garrett getting out there. And I want to address that by directing your honors to what the court said, what the Court of Criminal Appeals said in Johnson v. State, which is a case that's cited extensively in both parties' briefs. But that case, like this one, it was an investigation involving a death in a home that a 911 call was made and police came out and conducted an investigation. And the same type of argument was made in that case about how many times the police went into the home to look for evidence. And I'm going to quote from the opinion. The Court of Criminal Appeals in Johnson said, the lawfulness of a search is not determined by the number of times that officers cross the threshold. Rather, it is whether the officers engaged in objectively reasonable conduct under the circumstances. And that really gets to the crux of the first issue that counsel briefed on in this case, dealing with the protective sweeps and officers going in and looking for people in this fraternity house. The real issue before your honors today is, did the trial court abuse its discretion in finding that the officers under those unique circumstances as they existed that morning were reasonable in their belief that people could be in danger. And the testimony in the record, I know Sergeant Taylor specifically testified to this, that he subjectively has been to drug overdose calls where there were multiple people who overdosed in the same place at the same time. And the testimony that the trial court heard from multiple officers, not just Sergeant Taylor, was that there was a concern that in a fraternity house where there had clearly been a party going on, there was testimony about that, there were lots of people there. If one person took something that killed him, their concern was someone else in that house could be taking the same thing. The officers at the scene knew the body had been moved. Mr. Thibodeau said in his argument moments ago that the 911 calls pertained to Anton Gridnev, and in retrospect, that's true. But the officers at the scene didn't know that. In some of the 911 calls, and maybe in all of them, I can't recall off the top of my head, but I know in at least two of them, Anton Gridnev was not named. The officers didn't know if these were calls about the same person or different people. And I think all of the officers that testified in the hearing that responded initially said, we didn't know if there were multiple people who may be in danger, and we needed to get eyes on people to make sure they were safe and didn't need assistance, and to try to find out what caused the death of this young man inside this house. And that actually gets to another issue that I wanted to highlight for the court this morning, and that is a fundamental contradiction upon which the appellant's argument is based. Because in his brief and in his argument to you this morning, the appellant has made crystal clear that the only space that he is claiming a constitutionally protected privacy interest in is one room in that house, room 216 to be specific. And yet in his brief, and by extension in his arguments here today, appellant is asking this court to excise out of the probable cause affidavit, the search warrant affidavit, evidence that was seen in at least 9 other rooms in that house, rooms to which appellant himself concedes or argues that he had no expectation of privacy in and no standing to challenge a search in. Because what the probable cause affidavit lists are 12 separate spaces inside that house. And Mr. Thibodeau is correct. The record shows that there were 25, if memory serves, 25 bedrooms in this residence, plus multiple common areas. On the face of the search warrant affidavit, it lists 12 specific areas in that house, 2 common areas and 10 bedrooms in the Sigma Nu house, in which officers observed either drugs, drug paraphernalia, or other evidence of criminal activity, including, unfortunately, the body of Anton Gridnev, who was in the entryway.
Are you suggesting that we have to split the standing argument between standing to assert protection in room 215, 216, whatever his room was, versus the rest of the complex?
I'm suggesting that the appellant doesn't get to have it both ways. He's going to great lengths to say he only had a privacy interest in one room, but then he asked this court to impose constitutional protection over the whole house by excluding evidence that was seen anywhere other than room 216. And if you
Does it matter?
It does matter, and here's why it matters. Because let's assume that on the law, and I don't concede this and I don't believe this, but let's assume on the law, appellant is right, that the warrantless entries or views into room 216 were not supported under law. The remedy would be to excise out of the search warrant affidavit any reference to room 216. What you are left with then in the 4 corners of the search warrant affidavit is evidence of criminal activity that was in 2 common areas, the pool room and the entryway, including the body of Anton Gridnev, and 9 other bedrooms out of 25. So more than 1/3 of the bedrooms in the house. That generates probable cause. I think any reasonable magistrate could find probable cause to search the entire building at that point. And if the entire premises is suspect, then the search warrant doesn't have to specify which room. And if you have evidence in plain view in more than 1/3 of the bedrooms plus common areas, including but not limited to a dead body, that constitutes probable cause for the entire structure.
Okay, let's flip this. Okay, let you go ahead with your second point first.
And that gets to another issue. Counsel is asking this court to presume that these sweeps that the officers made, or that the views into all of the bedrooms were done illegally, but the record does not support that presumption. In fact, the record shows the opposite, because what the officers testified to is that as they went through the house, many doors were already open, and others, they knocked on them and people voluntarily opened the doors as the officers were in the hallways, which are common areas of this house. Officer Ben Ramsier from the College Station Police Department testified in the suppression hearing that a majority of doors that he encountered were already open. And so the trial court
how does the door already being open in these circumstances give an officer, assuming he didn't otherwise have the authority to go in? I mean, I grew up in East Texas and we had lots of open doors and unlocked doors.
Well, and I want to be clear, when I say open doors, I mean literally standing open is I think what is in the record.
And you know that if a thief had walked in and taken a laptop out of there, that's burglary, whether he had to open the doorway or not.
Well, but the difference is here, if a thief or if a police officer or anybody is standing in the hallway, which is a common area in the house, which under the circumstances, and you have a fatality in the house, the officers clearly have a right to be in the hallway. If they look through an open door and see clear evidence of a crime, that's plain view, and that's well established in case law. And what's significant here is the officers, even though they were seeing that evidence in plain view, did not seize it because they were not conducting a search for evidence. They were looking for people. They left it in place. They did exactly what the law wants them to do, which is leave everything in place, preserve the status quo by getting the people out of the scene, and backing out and getting a search warrant, which is exactly
Counsel, I'm going to have to give you a hard time here on how did they see the mushrooms on the shelves in the closet if they were looking for people?
Well, I believe what the testimony in the record was, they checked anywhere where a person could be, and I don't remember which officer it was, but I know one officer specifically testified that the closets in this house were large enough to conceal a person. But in other rooms, and there's testimony on the record on this, they looked in a room, there's stuff sitting out on a table, sitting out on a dresser. These are the kinds of things that the officers were seeing. Marijuana, white powdery substances, bongs, pipes, things of that nature. That's what the officers were seeing as they went through. And again, you don't get to have it both ways. You can't claim only this room is my protected area, the hallway outside is not. But if the doors are open and the officer looks in there and sees stuff, we can't use that. That's plain view. And the record does not show, it just doesn't, that all of these entries into all of these other rooms were done unlawfully without consent, or that the doors were closed and the officers had to open them. The record just doesn't support that.
I guess what I'm struggling with here is comparing this to another situation where you've got, say, a hotel that has a lobby, inside doors, common space. In other words, just this structure, but it's a hotel instead.
Sure.
And there's a party there and there's 10 people that have their doors open and there's contraband that is openly visible. I still have an issue of where is the authority for the police officer to go in the rooms in the hotel that are not seen. I mean, that can't be seen. I mean, where is their authority to go and in the open plain view doctrine, what is their authority to be where they can see what's in these other rooms?
Well, I guess the answer to that question as it pertains to this case, and this goes directly to address Mr. Thibodeau's argument vis-a-vis Rodriguez, which was a dormitory case, is in Rodriguez, there wasn't a 911 call about a death into that dorm. Here, the residents of that house, including, as appellant points out in his brief, Samuel Patterson, he wasn't on the phone, but as counsel notes in his brief, he was essentially a party to that call. They called 911, and that puts us into the realm of Johnson. It puts us into the realm of Wera. I find it interesting that in his argument a moment ago and in his brief, Mr. Thibodeau cites Gray as an example of why the officer's actions in this case were not proper. The issue with Bray was medics responded first, determined that there was no emergency, and then left, and then the police came in and did what they did. That's not this case. Anton Gridnev was still there. In fact, one of the first officers, Sergeant Taylor, did CPR on Anton Gridnev, and that's in the record. This case falls more in line with a case out of the El Paso court, and I don't believe this is in our brief, but it's a case called Villanueva v. State. And in that case, it was a 911 call about a drug overdose, and an officer arrived, I believe in the case it said 2 minutes after the medics did, which is pretty close to what we have in this case. When the officer arrived, the medics were inside this house assessing the drug overdose victim. The officer entered the house, and when he got in there, he saw an envelope that he believed was consistent with narcotics packaging, and he positioned himself so he could see inside the envelope, and he discovered heroin. And the defense in that case argued Bray, just as Mr. Thibodeau did here today, and the court in holding that the officer was rightfully where he should have been, pointed out that the emergency was still ongoing. The fact that the medics got there 2 minutes earlier doesn't matter. That was an ongoing emergency. And here in the Sigma Nu case, the residents, the occupants of that house called 911, and under Johnson, under Wera, under Villanueva, under Brown, that invites police and emergency responders into that house to be in a position to see what they saw, which then generates probable cause for the search warrant. Yes, Justice Davis.
I want to talk a minute about the dependence or independence of each sweep, one on the other, and the potential of interlocking. Are you saying that, and I'm not saying you agree with it, but would you bear with me a minute? If sweep number 2 stands as a valid basis on its own feet, shall we say, and it, go with me further, that it's invalid or it was not proper, but sweep 1 was, does 1 support sweep 3 without the benefit of 2? Or the other way to say it is, do you have to have 1 and 2 to reach 3? Because we have the problem in 2, the language talking about policy, and this is what we do. And yet 1 really smacks more of exigent circumstances or something of an immediacy. And then 3 is the one where it's the inspector, the detective, does the logging of everything. It seems like they have to all fall together or stand together. How would you answer that?
I guess I would first address that by, again, referring you back to what the Court of Criminal Appeals said in Johnson, which is we do not determine the reasonableness of officers' actions by how many times they cross the threshold. And I think in this case, when police go out to a fraternity house and find a dead body in the entryway that had very clearly been moved there, and they didn't know where it originated from, they didn't know where he had taken, where the drugs were that killed him. They didn't know if he had injected himself or someone else. They didn't know if there were other people that needed assistance. And when you're dealing with those types of issues and those types of stakes, I think what the testimony in the record from Sergeant Taylor and Sergeant McCarthy was, our policy is if we do a sweep, a protective sweep looking for people, we do it twice to make sure we didn't miss anybody. And so that's what they did. And that accounts for the first two. And it's interesting, it's in the record during these sweeps, they actually did find another unconscious person. That they ended up not being a medical emergency, but they did locate another unconscious person in another part of the house.
But it was in a common space in the house.
I think he was on a couch is where they found him. Yes, sir. Going to the third issue, I think this is where, as Chief Justice Gray says, we start to intermingle the two issues that appellant briefed on. Because going to the third, if you want to, I wouldn't call it a sweep, but when Officer or Investigator Garrett went through the house logging rooms in preparation of the search warrant, that gets us back to, is this a multi-unit building or is this a single residence? And we've briefed this, but I think under WERA, and I respectfully disagree with Mr. Thibodeau. I don't think WERA is inapplicable at all. I think the court's analysis in WERA is very much applicable here, including when the court specifically says members of a fraternity are more akin to roommates sharing a single residence. And if this is a single residence, then consent trumps everything else under Johnson and that line of cases, because they called 911, and that would deal with the third entry because by Investigator Garrett, because consent was never revoked, and multiple officers testified that no one ever told them to leave. And so I think that would address the third entry or the third logging of rooms in preparation of the search warrant.
John, you've been trying to ask a question for a while.
Well, I appreciate it. You partially, I think we're getting to, and it is probably because we directed you towards a certain end, but you didn't seem to hit much on the standing of Mr. Patterson to be able to claim his Fourth Amendment protections to room 216. I don't believe you're conceding that he had standing.
Actually,
or are
Your Honor, I agree that in a general sense,
okay,
he did have standing. Okay, and this is what's kind of interesting in this case. Our position has always been, and it was at the suppression hearing, that the protected place was not room 216 in the case of Sam Patterson. It was the Sigma Nu house. It was 550 Fraternity Way. It was the same place listed, incidentally, in the lease that Sam Patterson signed. That was not room 216. The only premises listed in that lease was 550 Fraternity Way. And that's why when Mr. Thibodeau makes his arguments today, he touched on emergency doctrine and he touched on exigency. He didn't touch on consent, because if that whole house is one residence, and I believe this, that the appellant had a constitutional interest, again, under the court's analysis, First Circuit's analysis in WERA, I believe the constitutionally protected place was the entire house. But once that 911 call is made under Johnson and under Brown, the residents, including appellant, are consensually letting police in to conduct what the case law says is a reasonable investigation into the circumstances of the emergency, which in this case, unfortunately, is the death of Anton Gridna.
So, and I misunderstood earlier, I guess, that he's not you're not contesting that he has a right to assert his Fourth Amendment protections as to just his room 216, but you're saying that you concede that he has that right to protection to the house. Is that what?
I think that's correct, Judge, because Justice Neal, I'm sorry, just as in Rodriguez, we don't take any issue with the holding in Rodriguez that there is a constitutionally protected interest, privacy interest in a dorm room, for example. Factually, this case is radically different from Rodriguez. In a dorm is very different from a fraternity house. I will tell your honors this briefly. In my analysis, looking at this case, I've only found one case anywhere in the country that was pretty close to on point factually with this case, and it was a 1982 case out of Pennsylvania called Commonwealth versus Fringell. And just very briefly, I know my time has expired, but what happened in Fringell was there was a sexual assault reported in a fraternity house, but the victim didn't know exactly where in the fraternity house. And the sheriff got a search warrant for the entire fraternity house. And the defendant in that case made precisely the same argument that Mr. Patterson is making here. And in deciding that a general warrant was appropriate under those circumstances, the court noted that there was no way for police to know exactly in what room a crime had happened or evidence of criminal activity would be found. And significantly, they cited the relationship between the residents. These were all members of a fraternity who all chose to associate together, live in that place under a hierarchical structure with elected officials and things like that within a fraternity, of which, by the way, Mr. Patterson was one of those elected officials. And in that case, they said a general warrant was appropriate. But that's the only case I could find that was pretty close to on point.
Thank you.
Yes, sir.
Okay, I've got to develop one other kind of thought that I'm struggling with. It's two parts. If I understand your argument, if they had moved Mr. Grednev 6 or 10 more feet and moved him to the porch and closed the front door, the police would not have had any authority to go into the residence until they got a search warrant.
I don't know that I would agree with that under Brown and Johnson, because if it was clear, and again, fortunately, those are not facts that we have to address in this case because that was not the facts of this case. But under Brown and Johnson, the Court of Criminal Appeals has been pretty clear that if officers come out there with a 911 call relating to a death, in this case, they can conduct a reasonable investigation into that death. But again, I don't concede that point, Chief Justice Gray. But obviously, in this case, those are just not facts that we have to address because Anton Gridnev, although he had been moved, was still inside that house when officers arrived.
Well, if we're going to parse it that way, he also was still alive at that point, so it was not a death.
I don't know if that's true. The officers, what they testified to in the record is that he did not appear to be alive. They saw no signs of life. Medics did not testify in the suppression hearing. And so there was nothing in the record saying whether he had a pulse or things like that. But the testimony from the officers that did testify were that he did not appear alive at that point.
Okay. Second line of where I'm trying to flesh this out. Is there any reason that all 22 fraternity brothers that were there could not have been charged with this, under your theory, this drug offense?
Well, that would, just like in McClellan, the court talked about how when you're talking about whether it's a multi-unit bit structure or a single unit structure, that's incredibly fact specific. And the same is true when you're making charging decisions in situations like this. That would be incredibly fact specific because as your honor is well aware, mere presence is not enough. We would have to, if we were going to charge somebody, we would have to have evidence of an affirmative link between each individual defendant and particular drugs. And ultimately, I think the charging decisions in this case, that's the decision that was made, is to charge people with the drugs that were found in their respective rooms, just to make those links clear. Is it possible to have charged other people? In theory, yes, it is, but it would depend on the facts and circumstances and the evidence's ability to show affirmative links between certain drugs and certain individuals.
So you believe that possession, custody, and control is not broken by the door to Patterson's room of any other member of the fraternity?
I'm sorry, I'm not sure I completely understand that question.
All right. And maybe I ask it backwards. You're contending that possession, custody, and control are of contraband is not limited by the room. In other words, if it was in the house, they were at least subject to a charge for possession, custody, and control of the contraband.
No, sir, I'm not saying that at all, because again, that's an incredibly fact-specific issue that would depend on affirmative links between individual potential defendants and individual drugs. And so it would just depend on, proximity. Is there some other evidence that an individual defendant knew about it or somehow exercised possession, care, custody, control, or management of it? Was there cell phone evidence? I mean, there's all kinds of things that could come into play. But I guess in a general sense, I agree with Your Honor that not talking about this particular set of facts, but in a global sense, it is correct. You do not have to, the drugs do not have to be in your room or even in your house or even on your person for you to be charged with possessing drugs.
Okay. Judges, anything else?
No.
Oh, all right. Thank you all very much.
You bet. You may proceed, counsel.
May it please the court. I'm going to start with the Johnson versus State and the Brown versus State cases. The cases that Mr. Calvert cited related to, I think he off the top, he went to Johnson. Johnson versus State is an implied consent case, as its companion case, Brown versus State. I briefed these cases in my appellant's brief. Both cases involved, Johnson versus State involved a homeowner who said, I just killed my husband. So that is radically different, both in terms of theory and in terms of the circumstance that exist here. In Brown, the homeowner actually invited the police into their home where incriminating evidence was found. The reasons that Johnson and Brown don't apply to this case is because it is Sam Patterson's room 216 that's entitled to privacy, just like Ms. Rodriguez's dorm room was entitled to privacy, not the dormitory generally, not the dormitory structure in which it was contained. And the case law in this area, I think, is replete. I cite Stoner versus California from the Supreme Court of the United States. A rented hotel room is entitled to an expectation of privacy. Moberg versus State, same, out of the Court of Criminal Appeals. State versus Granfield, that's the cell phone case, but again, the principle is still the same. McDonald versus United States, out of the United States Supreme Court. A rented room in a boarding house is entitled to an expectation of privacy. Brown and Johnson do not apply because the police were not invited into Sam Patterson's room. If there is an implied consent here, if there is a theory of implied consent, it is into the structure itself. It's into the foyer. It would be like into the hotel room, into a hotel lobby, I'm sorry, or a condominium complex, into a common space. Johnson just doesn't apply here. I didn't have a chance to get to it, but implied consent's not applicable here because the expectation of privacy that attaches is to 216, not the structure generally. Let me also address the second, the warrant affidavit, because I tried to find it. It's in there. I know it is. But what Riley Garrett told, again, 7 hours after, and again, the investigator is on the scene an hour and a half later, but in the affidavit, I know it's there somewhere. He says these are separately leased rooms. This is what Riley Garrett knows. And he's not just a garden variety detective. He's a special investigations unit investigator. tasked specifically with narcotics investigations. If anyone should know, he should. He's not some beat cop. He's a highly specialized, tasked individual. And he says specifically, as evidenced by the cross-referencing in the affidavit itself, these are separately leased rooms belonging to each of these individuals, listed specifically by room number. If there was implied consent to come into the structure, or in the foyer, bottom ground floor, there certainly wasn't for purposes of room 216. There's no evidence in the record from the suppression hearing which doors were open, which doors were closed, which rooms were open, shut, closed, or locked. There's none of that because they didn't keep track of it. And the second sweep, that they said we're going to do it as a matter of policy. That's in the record as well. Finally, on the emergency doctrine, again, it was tied to Grivnev. And when Grivnev left, the person in the foyer, just like when Mincy left, the emergency was over. The specifically circumcised emergency was over. Finally, I have to mention, Mark, there is a case on the emergency doctrine that the CCA, the Fort Worth Court of Appeals, reversed the trial court's suppression ruling involving firefighters and police entering into an apartment based on the community caretaking emergency doctrine. It's styled Martin versus State, 576 Southwest 3rd, 818. I think it's distinguishable on its face because the firefighter actually saw stuff while he was fighting a fire, then told the police officer. After the firefighter left, the officer goes in and sees he's in plain view. But that case has been granted on PDR. The Court of Criminal Appeals decided to take it up, even on that reversal. It cited Bray versus State. I mean, the Fort Worth Court of Appeals cited Bray, said our facts are different here, but the CCA has taken that up. The PDR has been granted on that case in October. The oral arguments are set for March. Thank you. Thank you. I'll entertain any other. Yes, sir. Yes, Justice.
I know it's not your position. I suspect your position sounds like is all or nothing, but as a secondary thought for the court to consider is because of the nature of the basis of each sweep, and bear with me, the third one, State's counsel says technically not a sweep, but bear with me, let's just call it the third sweep. Is there a carving situation here where the first one, because of exigency or other immediacy, survives as far as what happened and whether that is a proper search, and the second one doesn't because it's driven by department policy? We're not debating department policy, good thing, bad thing, that's not the point. It's different. And then you have to accumulate both of them to reach the third. Is it potentially possible that part of this is suppressed and the other part, or another sweep, one of the sweeps, one or more, survives?
Well, if I'll try to answer it this way, and to a certain extent, this goes to Chief Justice Gray's question earlier about what Riley Garrett knew, and this would really get to a good faith exception to a certain extent. But my position would be, because these were warrantless entries, it's the state's responsibility to establish specific probable cause as to 216. And I've argued this in my brief, that they cannot specifically say, because they don't know, they certainly documented the room that was breached, but they did not document which rooms were subject to plain viewing in the first sweep or the second sweep. So there is this dearth of information. And if they can establish the warrantless exception that would provide the basis for entry into the room, first or second entry, then I think they lose, because it's their responsibility to prove the exception. So if there was a basis for an emergency based on the community caretaking function, divorced from law enforcement on that first entry just to look. And again, I take the position it wasn't, and the extent of that was Chief Justice Gray's questions went to that. We don't know which, if it was a first or second, and it was the state's responsibility to establish the exception, so it fails. That would be my position, Judge. And I'm not sure that answers your question directly. I'm not sure you can carve this. I think it's more of a burden of proof issue.
Thank you.
Justices, any other questions for counsel?
No, thank you very much.
Thank both counsel, Ryan and Lane. Appreciate y'all's time. I see I've run over the time substantially, so our Q&A session may be over with before we get there, but we will move over to that now, which is another Zoom meeting. But this case is submitted and y'all are excused, and the court stands adjourned until 1:30 when we argue the case of Diaz, Ex parte Diaz. So thank y'all very much, and we will see y'all in the future. Thank you.
Tom,
Yeah, let me.
are we away from everybody?
No, we're not. We're still